Hello, I'm Michael Wood, and I'm going to be doing my practicum for HRM 303, Employment Law on Sex Harassment under California law. Here's the agenda I'm going to be following. First, I will discuss California sex harassment law. I will be talking about who is protected by the law, as well as who is liable under the law. Then I will go over personal liability of the harasser, as well as liability of the employer. Next, I will explain what is meant by supervisor in terms of sex harassment law. I will talk about what harassment by non-supervisory employees look like. I will discuss the two types of sex harassment, which are quid pro quo and hostile work environment. Then I will talk about the remedies under the law. I will then move on to some of the differences between federal or Title VII sex harassment law and California sex harassment law. I will wrap up the presentation by highlighting two sex harassment cases, Brooks versus City of San Mateo in 2000 and Harris versus Forklift Systems Volunteers in 1993, that were tried in federal court, and how the outcome of those cases would have been different if tried under the new California sex harassment laws, slated to take effect in January of 2019, in order to drive home the different nuances that exist between the two. So under California law, who is protected? Employees, applicants, contractors, volunteers, as well as unpaid interns. But who's liable? Not selective employers, but every single employer or prospective employer. In a nutshell, every person in the workplace, whether it's a supervisor, subordinate, co-worker, who is found liable for sex harassment, is personally liable for any damage that may have been caused by the unlawful harassment. Now let's talk about the personal liability of the harasser and of the employer. The individual themselves are personally liable for damages caused by their unlawful actions. The employer is strictly liable by its supervisors and agents. So who qualifies as a supervisor? If he or she has the discretion and or authority to hire, transfer, promote, assign, reward, discipline, or discharge other employees, or effectively recommend any of these actions, to act on the grievances of other employees, or to effectively recommend action on grievances, or to direct the claimant's daily work activities, then they are considered a supervisor. So does that mean non-supervisory employees are off the hook? Absolutely not. If the employer knew or should have known, let me say that again. If the employer knew or should have known about the harassing behavior and failed to act, they can also be liable for the harassment. Let's discuss the two different types of sexual harassment. First, there's quid pro quo, which is Latin for this, for that. You do this sexual favor for me, you can get a raise, or you can get promoted, or maybe you won't get fired. The other more common type is hostile work environment, which, important to note, could be harassing behaviors directed towards not only the complainant, but even merely witnessed by the complainant, to include widespread sexual favoritism that can include an ongoing consensual sexual relationship between a supervisor and employee that infects the workplace, in turn, making the environment hostile. Now we will discuss some of the remedies for sex harassment. First, you have injunctive relief, which could be simply corrective training or policy changes resulting from the harassment, economic damages, money, or non-economic damages, such as emotional or psychological distress. And then there's punitive damages, which are in addition to actual damages. They're intended to punish, reform, or deter the defendant's actions. So now let's look at California and federal sex harassment law side by side. So is there any difference at all between federal law and California law in terms of sex harassment? Take a look. On the left, you've got federal law. On the right, you have California law. Start with that top bullet. Negligence theory only. Employer not automatically liable. On the right side, strict liability. Employer is automatically liable for harassment by managers and supervisors. Go back to the left side. Employer is not liable if the employer exercised reasonable care and the employee unreasonably failed to take advantage of opportunities to avoid harm. Does that mean they tried to avoid the sexual harassment in every way possible? Now look at the right side. Employer has no defense if manager or supervisor is the harasser. Go back to the left side. 15 employees or more. Now back to California. All employers, even those employing one person or sole proprietors. Back to the left side. No application to independent contractors, volunteers, and unpaid interns. They have no protection. Under California law, includes independent contractors, volunteers, and unpaid interns. I want you all to think about that. What I want you to pay attention to on this slide is that first sentence. California employers are strictly liable. Translated, there is no defense for unlawful harassment by their supervisors. So what is legislature's intent under the new law? Under federal law and before the measure's passage, harassment must have been severe or pervasive in order to constitute actionable conduct. Under the new law, the legislature has expressed its intent that an employee need only prove that a reasonable person subjected to the discriminatory conduct would find that the harassment so altered working conditions as to make it more difficult to do the job. On this slide, I want you to pay attention to that second paragraph. The legislature intends that a stray remark uttered by a non-decision maker may be relevant circumstantial evidence of discrimination, affirming the decision in Reed versus Google in 2010, which rejected the stray remarks doctrine. If you get a chance offline, you should research Reed versus Google, 2010. In Brooks versus the City of San Mateo, 2000, Salvaggio, a male employee, made improper advances and touched the breast of a female employee. The Ninth Circuit Court of Appeals held that this single incident was insufficient to support a Title VII claim, but it also stated a different question would arise if Salvaggio were Brooks' supervisor rather than her coworker. Because the employer cloaks the supervisor with authority, we ordinarily attribute the supervisor's conduct directly to the employer. Thus, a sexual assault by a supervisor, even on a single occasion, may well be sufficiently severe so as to alter the conditions of employment and give rise to a hostile work environment claim. The Ninth Circuit Court of Appeals affirmed a summary judgment in favor of the defendant, where the alleged harassment consisted of the plaintiff's supervisor forcing his hand under her sweater and bra to fondle her bare breast. The plaintiff required psychological help and even then was unable to successfully return to her job. The Ninth Circuit held if a single incident can ever suffice to support a hostile work environment claim, the incident must be extremely severe. In Aldabog versus Greenpeace Incorporated, 1994, a single incident was held to be sufficient where the assailant slapped the plaintiff, tore off her shirt, beat her, hit her on the head with a radio, choked her with a phone cord, and ultimately forced her to have sex with him. The perpetrator held the victim captive overnight. When she finally managed to escape, she had to be hospitalized for her injuries. The court then concluded, the brief encounter between the plaintiff and the harasser was highly offensive, but nothing like the ordeal suffered by the unfortunate young woman in Aldabog. who was held captive from evening until early the next morning. Utilizing the factors of frequency, severity, and intensity of interference with working conditions, we cannot say that a reasonable woman in Brooks' position would consider the terms and conditions of her employment altered by the harasser's actions. In Harris versus Forklift Systems, Harris sued her former employer, Respondent Forklift Systems, claiming that the conduct of Forklift's president toward her constituted an abusive work environment because of her gender, in violation of Title VII of the Civil Rights Act of 1964. Declaring this to be a closed case, the district court found, among other things, that Forklift's president often insulted Harris because of her gender and often made her the target of unwanted sexual innuendos. However, the court concluded that the comments in question did not create an abusive environment because they were not so severe as to seriously affect psychological well-being or lead to her suffering injury. The Court of Appeals affirmed. What's important to note on these two cases is, had they been tried under the same California laws under the new legislature to take effect in January 2019, neither case would have been the same outcome. In both cases, the plaintiff would have won. Our lives begin to end the day we become silent about things that matter, by the late great civil rights activist Martin Luther King Jr. Thank you. I hope you learned something.